All right. Good morning, everyone. Thanks very much for joining. Welcome to um, the presentation. I want to start by, first of all, thanking Catherine, your leader at the North Shore Labor Council, for inviting me to speak with all of you this morning. A couple of housekeeping things as we get started. First of all, given our current work from home shelter in place issues, I need to be transparent and let you know that I have a very large dog who doesn't like it when people walk in front of the house. So if I'm suddenly going on mute, it's because Albie is unhappy with the neighbors. We are, so having said that, we are recording the presentation this morning for folks who were not able to join. And we will be able to make that available to the members after the presentation. This program is been certified for CLE, so I'm going to announce the CLE credit code a little bit later in the program, closer to the top of the hour, or closer to the end of the presentation. And afterwards, you will get a form. You just need to complete that and send it back to the firm. There'll be directions on the form, and the slides will also be made available, when we're done. So with that, why don't we go ahead and get started? Next slide, please. So many of you are, sorry, I was getting a text from your fearless leader, Catherine, wanted to make sure I was being heard, and I am, so thank you. I was looking at the presentation list last night, or the folks who signed up. There are a number of familiar names on it, so thank you for joining us this morning. So many of you know the firm, Seyfarth. We are, for those of you who don't know, are celebrating the firm's 75th anniversary this year. So here's our fancy new branding that we just did. And we are, as I said, 75 years strong this year. We started out here in Chicago as a union busting firm and have grown our reach substantially, both in Europe and in the Asia Pacific, and are now considered a full service firm for those of you who are not familiar with us. Next slide, please. So the firm has, throughout the COVID pandemic and craziness that has happened, has tried to stay on top of the various changes that have occurred. And so this tiny section here is the shameless self-promotion portion of the presentation. We have been trying to stay in front of the issues that have been keeping you all awake at night. If you have not signed up for the firm's nightly COVID briefings, I would encourage you to do so. On the firm's website, we've got this pretty slick return to business and post-pandemic checklist that's available to you just for downloading. As I said, we're a full-service firm. The corporate group within our office has been amazing, guiding people through both the CARES and the PPP program. If you have questions on that, feel free to reach out to me or one of the other Seyfarth attorneys that you may work with. We'd be happy to hook you up with the right folks. And just one other, as we go into kind of the return to work issues, I wanted to make you all aware of some webinars, micro webinars we're calling them, that are related to wage and hour issues that are going to be impacting folks as we return to work. If you have interest on that, please be in touch afterwards. Happy to connect you with the right folks on that. Next slide, please. So I do know a number of you. I've already gotten a couple of notes. Thank you. It's great to see you as well. Just wanted to give you a little bit of context so that you're all not concerned that I'm winging it here this morning. I've been with the firm now for about 14 years, been practicing for just over 20. I am on the trial team. I was in HR, like a number of you may have sat in those chairs. So I've sat in those chairs before. Deciding to be a lawyer, I'm 30 and I don't know what I want to be when I grow up standard. But I am now, have been with the firm for 14 years. I am one of the co-leads for our labor and employment group in Chicago, and I sit with sit on the lawyer development committee and am an ally on our firm's diversity committee. So with that, let's talk a little bit about our agenda for the morning. Next slide, please. When I spoke with Catherine about getting ready for the program this morning, she mentioned that you all come together and kind of consider these types of discussions as safe place is probably too strong a word, but certainly a place where you can share ideas and share information. And while I love doing presentations like this, I am most particularly comfortable when we've got a live audience, because I can cue off of what your questions are and what issues you may be having. If we were live and in person, I would tell you that this is your hour and a half, and so feel free to stop the presentation or raise your hand. It's a little harder in the WebEx context this morning. If you're in the presentation, you'll see that there's down in the lower right-hand corner, there's a chat function. You can certainly chat questions to me while we're going through the presentation. I will try and respond in real time to that and read the questions. You'll all see the questions in the box, but I will try and respond to those as we're going through it. I'll also try and leave some time at the end, so if we want to try and have questions at the end, certainly happy to do that. And I do want to run through, it is a little harder though, because we don't have the ability on this platform to have you come off mute and ask the question live. So I apologize for that, but we'll try and get them answered either real time at the end or afterwards if you want to connect separately. Now, I do know that a number of you, just given who you are and where you've worked before, or what you do now, is that a lot of these original topics that we're going to go through, you already know, or at least it's more of a refresher, kind of a let's set the table type discussion. And so I'm going to run through the first couple of these topics pretty quickly so that we can get to the more meat of the substance towards the end with the scenarios and some of the Q&A that Catherine had asked that we kind of go through. Next slide, please. So generally speaking, as I think everybody knows, and I saw Catherine had shared with me some of the questions that you all were throwing around with each other last week, everybody understands that when we talking about politics at work, we're talking about issues that might be considered quote unquote inflammatory. We all understand that unlike public employers, private employers do not have First Amendment rights, generally speaking. And so that everyone has the same baseline understanding. There's no general right to engage in political speech or activities in the workplace. Connecticut is the generally speaking exception in my statement because that state statute, their statutes there and their constitution do provide for some First Amendment protections for private employees. Next slide, please. And as you see here, this is kind of, I assume that most of you all know this, so just very briefly that there are states, and most states and counties have protections for folks for political affiliations or for protected using politics, voting, those types of things. There are certain states who have protections for those types of activities. A couple of states have, of course, prohibit retaliation based on the off-duty political activities, campaigning, that sort of thing. So again, kind of a table-setting expectation. Next slide, please. And as I'm sure most of you know, some political speech can qualify as considered protected activity under the National Labor Relations Act. Everybody knows it's the law that grants employees the right to form or join unions, engage in protected or concerted activities to address or improve working conditions. I think it's important to remember that the courts have found that the mutual aid or protection provision of the Act can, in limited circumstances, serve to protect the attendance at demonstrations targeted at workplace legislation. Examples when there were, the DACA protests or the folks who were protesting at the airports for the immigrants, that could be considered concerted protected activity. And so when coming up against questions of whether or not this is something that would or would not be protected, you need to kind of step back and look at it in the context of what's the message that the folks that are engaging in this conduct are trying to get back to the employer. Is it something that is a term or condition of employment? Is it something for the mutual aid or protection of a workplace-related topic? Then it probably, at least could, arguably fall under the protection of the National Labor Relations Act. And candidly, what qualifies as protected is in and of itself, a presentation, I've done that one several times. It's a multiple-hour presentation. And so, I think that we'll just assume that everybody understands that there are those types of protected conduct. I do want to, just in case you had not heard, last week the National Labor Relations Board decision came down in the General Motors and Charles Robinson case. And the board in that decision removed any blanket protections for employees who've engaged in abusive conduct towards their managers and then claimed that they engaged in protected activity. So it was good news in that regard from an employer standpoint. It has kind of reset the burden shifting for employees to make the initial showing that they had engaged in Section 7 protected activity, that the employer knew about that activity, and that the animus between the activity and any decision or any action that the employer took were connected. And so the ability for an individual just to go off and haul off on their supervisor or yell and scream and make a scene while previously had been protected, that has been rolled back slightly, and good news in that regard. Next slide, please. So, and as you also know, there are a number of states who have enacted off-duty conduct statutes. Next slide. And so fundamentally, I think we all agree from an off-duty conduct standpoint that there is a right to privacy generally for activities that occur outside of the workplace, obviously not in the workplace, because we can certainly be involved or look into what's happening in the workplace. And of course, many states recognize public policy exceptions to whatever general at-will employment standard that there is. Thinking like voting, jury duty, that kind of thing. Those are the types of public policy, fully mandated, understood, accepted by all exceptions to the at-will standard. In Illinois specifically, Illinois only recognizes public policies that are, in fact, clearly mandated. As you all know, the two big ones are always firing someone for asserting a workers' comp claim or for refusing to engage in illegal conduct, reporting other illegal activity or conduct. But it also can protect engaging in the criminal justice process, participating in the judicial or regulatory process if somebody engages in, an OSHA complaint, that could jump into the line of a clearly mandated public policy. So again, as we look at, what is considered off-duty conduct, or does it bleed over into the workplace? That's when we need to start thinking about, is this something that could be protected? Is it part of the public policy, or is it something that, as an organization, you have the right to look into? So next slide, please. So you kind of back to this concept of privacy. Many states want to recognize that kind of the what happens at home stays at home concept, and more than half of the U.S. states have created some type of off-duty conduct. Those states that do govern or protect that type of conduct vary in scope and almost always limit the off-duty conduct by a qualification which effectively provides protections that the statute will not apply if the conduct in question has a demonstrable relationship to the employer's business. So what does that mean? We see that a lot in the hiring context. When some manager decides to go rogue and Google his or her next hire, and they find out that the person blogs about their activities outside of work, or maybe those activities are perhaps not in keeping with what you might otherwise consider your corporate values. That's when we get into, is this in violation of an off-duty conduct statute? And so, when we get into situations like that, we often kind of have to talk the managers back off the ledge, as you know, about rescinding offers, unless rescinding an offer to someone whose off-duty conduct may be considered somewhat untoward, so that unless you can show that there is some sort of demonstrable relationship between what this person's doing when they're not at work and how it might impact their abilities to be effective while at work. And we're seeing it more and more, as I'm sure you all are as well, but we're certainly seeing from questions that come into the firm and then get dispersed amongst our teams. You know, in the world of social media and news and how they're all kind of bleeding into our day-to-day conversations, one of the scenarios that we're going to talk about a little bit later is exactly how to respond to those types of complaints. If somebody's doing something off work, they're posting something on their personal social media, you know, if that comes into the workplace, what is the appropriate response for you as the employer if and when it gets raised to your attention? And these aren't easy topics. I mean, I think you know, I'm sure you all for the last several months, much like we have, feel like you've kind of been drinking from the fire hose, trying to respond to, you know, scenarios that you'd never anticipated 3 to 4 or 5, 6 months ago. You know, I think we're all desperately hoping for a pre-COVID world to return, but I don't think that's actually going to happen anytime soon. You know, so give yourself a little bit of credit, pat yourselves on the back. I think you're all probably doing things the right way, and my hope is that with the rest of the presentation that we talk a little bit about, you know, just some things to be aware of as you go through your day-to-day conversation. So, next slide, please. So back to the topic of, you know, more specifically on off-duty conduct, there are the states that you see highlighted here all have laws that prohibit employers from disciplining an employee for engaging in certain types of lawful conduct during off-duty hours. And that's typically what the statutes say, that they contain a qualifier that the off-duty conduct must be legal. And here again, you know, we get into some gray areas. You know, there's some, let's take an easy example, marijuana. Everybody knows it's legal now in Illinois. Recreational use of marijuana at a beach over the weekend, find out about it Monday at the workplace, probably not something that an employer needs to address. Let's take it one step further. Let's say the same employee brings marijuana to a coworker's party, socially distant, of course. Then we've got a little bit more of a gray area. You know, somebody, you're still at a private residence, probably would not recommend intervening if there was a complaint or you just learned about it. There's no reason to go and, you know, investigate that sort of scenario, unless, you know, and this is where I think the unless is kind of blanket to all of the off-duty conduct topics, is unless it starts to bleed over into the workplace. And so if a co-employee comes forward and says, hey, this person was acting inappropriately, it was all a group of work employees, then, you know, if it seems like to you that it's going to bleed over into the workplace, you probably need to think about at least having a conversation with the people involved, seeing if there was any sort of a policy violation. You know, and again, off-duty versus on-duty, there is a distinction there. But when it starts to bleed over into the workplace, then I think you need to at least sit up and take notice as to what's happening. Obviously, taking the same example one extreme further, you know, in a pre-COVID world, if somebody brought marijuana to, you know, nobody's having company picnics anymore. Excuse me. But if somebody had, if you say you had a company picnic, we had an event scheduled at the Brookfield Zoo this summer, that's obviously not going to happen. If somebody had come in and violated, you know, the no controlled substances or no alcohol on a company event, then in my opinion, that's a hard stop. You know, that's now probably violates policy. You need to probably, I would recommend, if you called me, I would recommend that you investigate, you take action. You know, that's a little bit easier, more black and white than the gray area with some of the off-duty conduct issues. Excuse me. The other thing to consider is that there's also, with off-duty conduct, there is the possibility that could, or when you do have that demonstrable relationship that we were just talking about, meaning that if someone has conduct that you become aware of, you know, it's off-duty, say the person you're about to hire, you think you're going to be hiring your communications manager or your chief marketing officer, and in doing your diligence and getting ready to hire that person, you realize that that person's also a card-carrying member of either the Nazi Party or the KKK, let's say, then you might run into you know, some significant concerns whether that individual can effectively engage in conduct on your company's behalf, because there might be, or at least an arguable demonstrative relationship between that person's personal views, their off-duty conduct, and the work that they may do in the future. not saying it's 100%, it's not a slam dunk, but certainly it's something that you're going to want to investigate, because then what you don't want to do is run into a situation where you're suddenly someone speaking potentially on the company's behalf, saying things that you would not embrace as an organization. So that's when the off-duty conduct can bleed into the workplace and could be become problematic. Next slide, please. And these we're just going to, again, you probably know all of these, but the Illinois has a specific off-duty conduct statute that protects the lawful use of products, and it's essentially for marijuana, but also for other legal substances. Next slide, please. New York has a similar off-duty conduct. This is, and you'll see where it says the individual's legal recreational activities outside of the workplace or outside of work hours. Next slide. But of course, leave it to New York to make it a little bit more complicated, because the exceptions to that statute say that for legal recreational activities could be construed to allow for broader protections under the categories of political activities, which is also protected. Makes it a little bit, again, nuanced. Next slide, please. And finally, California, because it's California, protects employees for lawful conduct occurring during non-working hours and away from employer premises. And just as a note, California is the only state that expressly is applying these protections to applicants as well as employees. I see there's a question that came in here. Couple questions. Let me stop there before we move into the next section. So Deborah's question, does it matter if the person involved is in leadership? If you're speaking about the off-duty conduct, yeah, I think it does. I think it could. I mean, this is the classic where it depends answer. I think that if someone is in leadership or expected to set the expectation of good behavior, and they're engaging in some off-duty conduct that could be considered illegal, untoward, something that might bring a level of spotlight, big bright spotlight shining on the company, I think that there could be an opportunity, at least for a discussion with that individual, and certainly depending upon the severity of the conduct, yes, there could be an issue with that person, particularly if they're in leadership. Let's see, there's a question. The second question here: our company has stated its support for Black Lives Matter. We're going to talk about that in just a section, or in just a second. We're going to be moving to that. And if someone on social media is criticizing Black Lives Matter, can we discipline, decide the employee isn't fit for a management position, and what if the person suggests violence? Okay, so yeah, we're going to talk about this right now. We want to move on to the next slide, because I think that's exactly where we're getting it. We're seeing a lot of activity in this particular topic right now. One of the questions that came in from Catherine before we started the presentation, and I'll just share it back with you, and I think it looks like, Susan, to your question, it says, in our current social and political environment, as can be expected, we've had a surge of complaints regarding employee political statements or displays of socially charged symbols on social media, clothing, t-shirts, hats, buttons, bags, and on vehicles, mostly outside of the workplace, although expressions posted on vehicles in our parking lots have also become an issue. This is not only the Black Lives Matter, but also we're hearing a lot of complaints about the MAGA hats, Make America Great Again. And certainly over the course of the last couple of weeks, you've seen the news with the banning of the Confederate flag. Why did that take so long? But but those are the types of things that we're certainly seeing a significant amount of traffic and chatter on. Next slide, please. So Susan, to go back to your particular question, I think the question that you all need to be asking yourselves is, what is the messaging that's at issue? And is the message in contrast to the stance that the company has taken on a particular topic? And as you know, and it may be your own organization, many companies have taken or have re-emphasized their diversity inclusion stance, their anti-discrimination, anti-harassment policies in the wake of George Floyd's murder, and that there's been a lot of discussion around all of that, both in the media and in social media, personal conversations. Many of you may have seen the complaint that was filed at the end of last week against Whole Foods. It was a class action complaint out of Massachusetts. According to the complaint, the company terminated individuals for wearing the Black Lives Matter branded or I Can't Breathe face coverings. It's interesting, in the complaint at least, they made the allegations that the company was being, what I'm looking for, divergence the wrong word, but that they weren't being, I guess, two-sided in their communications. One, from a public relations standpoint, they were saying that they agreed with and they wanted to promote this particular movement, but then according to the complaint, they were terminating individuals for actually then wearing those types of branded face wear in the workplace. Obviously, there's two sides to every story. I don't know the details of that particular situation. You know, the firm is not involved in that, nor would I talk about it if we were. But at least from the articles that I've read, that the company said that the individual who's the lead plaintiff in that case was terminated for attendance and other performance issues. I think we have to wait and see. But before we talk a little bit more specifically about Susan's questions or about how to respond to those types of questions, remember that we kind of go back to the NLRA protections. Again, what is the message that is being presented by the wearer of this particular apparel? I think there's a distinction that needs to be made between, again, is this concerted protected activity? Is this to the aid and mutual benefit activity, potentially? Or is this simply just and I don't mean to denigrate it. I don't mean to say simply like it's not a big deal. I think it's a very important conversation to be having right now. But it is a social conversation versus a workplace conversation. And so I think for a number of organizations, it's been that distinction between the speech that has been very important to the decision-making process. If we back up 10 years ago, when suddenly everybody was, we were doing social media platform discussions and presentations, like, what can people say? And there was this big, long, hundreds of page white paper that came out by the National Labor Relations Board that talked about, what was protected speech and what wasn't protected speech. And when I would do these presentations 10 years ago, it's very similar to what we're telling people today. Peel back the layer. What are we talking about? Is this, whether they say it on social media or if they say it, standing at the time clock, if the content of their conversation is, for the terms and working conditions, we don't like this particular supervisor. We're not getting paid enough. We think the vacation policy stinks. Those are probably, and not probably, those would be protected, or at least arguably protected under the Act. On the Black Lives Matters issues, arguably that could be construed as simply a social issue. And again, I'm not denigrating the topic, but it is not necessarily one that is protected under the Act, because it goes to what's happening out in the world as opposed to happening in the specific workplace. Now, of course, it can bleed over into the workplace, and I think that's where Susan's question is going, is that what happens if someone is acting in the manner where they're what if the person suggests violence towards the Black Lives Matter protesters? Then I think, again, peel back, where it's being said, but does that conduct or do those comments otherwise violate your company policy? I'm assuming, as most companies do, that you have a policy that says we will not we will not engage in or allow violence or violent conduct in the workplace. Now, again, this isn't in the workplace because it's out on its social media, but if you learn about it because employees are bringing it into the workplace, then I think you have to make a determination as to whether or not, because it's now in the workplace, whether or not that's a topic that you need to address. Without knowing a lot of the other details, Susan, to your question, I think yes, if it's come to you from other employees or potentially even outside customers, then I think you do have an obligation to at the very least investigate it and determine whether or not there's a reason to either discipline or remove that individual from the organization. And we're going to talk about that a little bit more in just a second. So. Again, with the social media, remember that if somebody is, and certainly if they were to go so far as to say, speak on behalf of the organization, to Deborah's earlier question, does it matter if the person is in leadership? If they're suggesting in some way that they are, this is communicating the company's view on this particular topic, then again, you're into that demonstrable relationship of, now we are crossing over. This is no longer off duty. Now it is on duty. And so I think if it is divergent from what you would otherwise embrace as an organization, then yes, I think you've got an opportunity to, at the very least, have a conversation with that person and potentially, move beyond all of that. And I guess, so then the question is, how do you know when to do that? Either of those things happen that we talked about a minute ago. If it's, a customer brings it forward, if you see it because you happen to be friends with that individual, if it violates a company policy or the code of ethics or the law for that matter. I mean, if what this person has suggested could be considered hate speech, then I think you have an obligation. I would encourage you when they come into the workplace to do something about it, to investigate it, to have a conversation with the managers, in the organization as to, the type of conduct that you don't want to bleed over into the workplace. And remember, it's not just, I'm in my mid-50s now. And so I rarely ever look at anything other than Facebook or maybe Twitter eventually. But remember that with the younger crowds, there are a number of other platforms that you at least need to be aware of, platforms that I think I probably need my 14-year-old niece to explain to me. But, in terms of, not just assuming that there's one or two platforms out there, just again, be aware that it could come to you in a variety of different, or the complaints could come to you in a variety of different ways. Next slide, please. So one of the questions that had come to me from Catherine, from you actually, one of your members, a few weeks ago said, I'm wondering what approach the organization is planning on taking with regard to political opinions, personal commentary, or specific social issues being posted on the company's internal or external posting sites. And again, regardless if it's bulletin board or some sort of an internal chat box. And will you more closely monitor or edit posting sites so as decides what is company relevant? And I think some of the answers that you all came back with would be the same ones that I would suggest if you were to call me to discuss it. The first one is that many companies simply say across the board, period, full stop, that we don't allow political postings of any sort. That's, generally, I think the way that most companies, I think, are pulling back from, and I don't want to jump into a story that I want to tell as part of the scenario, but that I think they're recognizing that this is kind of the no good deed goes unpunished scenario. You want to be supportive. You want to acknowledge that there is a more robust conversation that needs to happen in the workplace or in society generally. But it's amazing to me how many people kind of show their true underside and don't necessarily agree that this is the right conversation to be having. I mean, just on a personal note, I had a very difficult conversation with a group of people in our little social tennis club here where I live over the weekend. And very quickly it devolved into some pretty nasty dialogue between the kind of two factions of, almost to the point where like, do you not want to be diverse? I mean, it just didn't make sense to me. So it is a very difficult and a very real conversation that people are having right now. So, it's tough. And I think, again, pat yourselves on the back, give yourselves a little bit of credit because, it's going to be one of those where you may not be comfortable with the conversation and you need to push your leaders, you need to push your coworkers to recognize that there are multiple, there are multiple sides to this, and you need to be aware and cognizant of these others. But you also have to recognize that if it is going, whatever somebody's saying, if it's going to somehow violate some other company policy, code of conduct, anti-harassment, those are real things that you need to be considering, and you need to be consistent in how you're going to be responding to this. All right, I'm going on mute real quick. No, maybe not. Okay, dog's going to be quiet. There you go. Somebody was walking by. Next slide, please. So here are just a couple of examples, excuse me, as I would say, of when the content or the comments can cross the line. If there's, if it looks like, and these would be some, again, if you think just about social media generally, if you think about, somebody, a heated argument in the lunchroom, if there's a conversation online that, that devolves, are any of these types of issues occurring in that conversation? And if they are, then I think it's time to step in. And one of the topics that got raised was what about the whole idea of we have not been doing a good job of this before now, that we were a little lax in our enforcement of these types of policies prior to COVID, prior to the Black Lives Matter movement developing and really taking some traction. If these other issues have slipped by before, don't fear. It's not too late, in my opinion. I'm a big fan of recommunicating and republishing policies when the moment seems right. And frankly, in light of the upcoming election in the next couple of months, I think the moment seems right. I think now is a good time for you to let all of your employees know that going forward, these are topics that we are aware are important to you all, but we will, and we will allow to the extent that they are respectful. But if it gets, if it gets to the point where one of these company policies get violated or there's some level of disruption, that as an organization you're going to need to step in. And I think by doing that, it gives you as the employer an opportunity to identify or fix any of the issues that you felt may have been a little lackadaisical in the past, your responses. But then going forward, reset the expectation and then be consistent in how you are going to apply it. Any questions on that before I've got one other point I want to make, and then I'm going to jump into a couple of scenarios. Any questions from the group here? Okay, next slide, please. Okay, so this isn't specifically on any of the off-duty conduct. Well, maybe a little bit, but Catherine had mentioned during our call earlier in the week that a couple of questions have floated up about the existing travel bans in the city of Chicago, Cook County generally. I'm sure you all know, but the city of Chicago has an ongoing list that they are publishing from a travel ban standpoint. If you've driven in either on, coming down from the north or coming in from, on the Indiana south side, you see the signs on 9094 that says if you've been in a hot spot, please self-quarantine for 14 days. I think the question that a lot of people have is, how are we going to enforce that? I know that there was an article in the Tribune just yesterday that talked about this topic because, in case you had not heard, Wisconsin went on the list Tuesday. And so the Wisconsin travel ban, or the travel from, if one travels to Wisconsin, that state is now on the self-quarantine ban. And it essentially states that if you are arriving from a high incident state, this is the Illinois or the Chicago ordinance. If you're arriving from a high incident state, or if you've visited a high incident state for more than 24 hours, it's recommended to self-quarantine for 14 days after arrival or for the duration of your stay, whichever is shorter. Now, they did, luckily, because some of you North Shore folks who truly have, employees coming back and forth from Wisconsin, there was an exception, or I guess an exception is the best way to explain it. First of all, essential workers with verification from their employer who are traveling for medical care or parental custody are exempt from those recommendations. The ban applies, obviously, to states that have an average of more than 15 new COVID cases per 100,000 residents. And the current organization, there was in this article from yesterday's papers said that they could begin fining people who violate the ordinance $500 a day, up to $7,000 if it's determined that the person involved flaunted the guidelines or that they were not following the self-quarantine. Again, I'm not sure how this is going to get enforced. They've been a little vague on all of that. There was reference in this article in the Tribune yesterday to the contact tracing, et cetera, but it's just something of which to be aware. Specifically, again, with respect to Wisconsin, the Chicago FAQ does allow employees who live in Wisconsin but who commute to Chicago for work to do so, subject to some requirements, and it's the ones that we've seen. Limiting their activity to work-related activities and functions that directly support those activities, to avoid public places as much as possible, monitor temperature, signs of symptoms, wear a mask, maintain social distance, clean and disinfect the workplace, and then essential workers are required to the extent possible to avoid extended periods in public contact with strangers and large congregate settings. And so that's directly from the Chicago FAQ on the ban, or on the travel ban, or quarantine, because travel ban has an even broader. I think we're getting a lot of questions on this. The biggest question is, what are they going to do about enforcement? We don't have answers for that. So I just am putting it out there and to put it on your radar to ensure that you're thinking about it as as we move into a more open, back to work type environment. Okay, next slide, please. Actually, two. Why don't we just go ahead and move on to the first kind of real world example. Before I jump into this, does anybody have any questions at this point? Hearing none. So this first scenario, and so I've got three here, and all of these are ones that my office has received in the last 2 weeks as we've seen more of an open return to work plan. And, the first one is a couple weeks ago when the protests were, I think, happening much more frequently, was that an employee approaches and says they want to take a day off or get a change in their work schedule to attend a protest. In this particular real world, kind of ripped from the headlines scenario, the person wanted to travel out of Chicago to, I think it was to Washington, D.C. for a protest. and just simply wanted to take the time off because the person felt it was the right thing to do. I personally would not just say, sure, go ahead. It seems fine to me. I think that this one seemed a little simple to me. I was kind of surprised it came up as a question, but again, I want to make sure that it's on your radar. There are certainly their policies regarding attendance, vacation. You certainly don't have in this, particularly in the political climate, a requirement to change or accommodate an employee's schedule for any sort of off-site political activities. But I think you do need to be aware of, some questions to be thinking about. Has anybody else ever made a request like that? What did you do? It's the whole consistency is key. Expectation that you're not going to be treating one person differently because you agree or support that particular cause versus, we don't like the fact that this person's going to some other type of rally. I think being neutral, being Switzerland in this particular type of scenario is going to serve you and the organization well. Being consistent, did the person request, the time off properly? You can't just allow people willy-nilly take time off. And it's, I think, particularly important to be thinking about this if, there might have, again, this is kind of where you go back and level set. If we had done it in the past, we didn't like the way it worked in the past, this is the way we're going to do it going forward. This is going to be important so that we are consistent each and every time this type of conversation comes up. Do they have the time available? Are they otherwise going to have to take attendance points? Has that been communicated to the individual? I think all of those are going to be important to ensuring that if you get challenged on it, that you have an understanding as to why you made the decision that you did. Last week, Monday, I think it was, you all made, those of you who are on our mailing lists, you may have seen that there was a concern, or at least a topic that went out about a discussion around the strike for Black Lives. It was supposed to happen last Monday. And it was either a full day strike, that people were just going to not come to work in support of this strike for Black Lives, or it was going to be, quote unquote, a strike for the period of time that the officer was on George Floyd's neck. And so that was, under 10 minutes. And was that going to be considered a strike? And what, if anything, to either scenario should employers do about it? And I think there was a lot of discussion from some clients about, was this something that we needed to address ahead of time? Was this something that we needed to, something that we wanted to address in advance? And interesting, we didn't get a lot of questions about the employers that we were discussing it with. Were not hearing about it from the floor. They heard about it from us. They heard about it from some of the other media presentations, but they weren't hearing about it out, within their operations. And so they were surprised, I think, pleasantly, that it didn't become a bigger issue. I think we originally thought that it was going to be a thing, and it actually didn't turn into a thing. So maybe over-prepared is better in that particular regard. Hold on a second. So my slides are suddenly backwards here. And then just finally, if somebody does, and you're aware of the fact that somebody's going to be out and doing this type of a protest, consider then what your back to work, return to work guidelines are. Does this person, were they someplace where they should otherwise have self-quarantined? Are you concerned that they would have been, exposed given, whatever, were the people at the protest wearing the mask, yada, yada. Again, not anything you need to address directly unless you're worried, unless you become aware of the circumstance where the person is not otherwise engaging in good kind of COVID protocols, wearing a mask, social distancing. So just things to be thinking about. Okay, next slide, please. Let's see what the problem is. Pages backwards here, so I couldn't figure out where I was going. All right, so now we're coming back to Susan's question about when a person wants to wear or asks to wear a face covering that has either the Black Lives Matter or some other political statement, on the face covering, on a T-shirt, that sort of thing. And this is kind of, the flip side of that Whole Foods case that I had just mentioned a little bit earlier, because in there, the company was, they were obviously supporting it, and of course, many other companies are supporting it. But I think where the issue comes in then is when you allow one, what happens, and if somebody else comes in with a much more inflammatory situation. And let me give you a real life example. Last week, I guess it was 2 weeks ago, a group of employees came to a client. They said, we want to wear these masks, the Black Lives Matter mask. The company said it was fine, absolutely no problem. And there wasn't any issue at it wasn't a warehouse, but it was at the production facility where these people worked. This was down in a southern area state. And the following week, a group of employees showed up wearing White Lives Matter T-shirts. And then they had a bigger problem because I think, the issue there is, that is a much more, in my opinion, inflammatory type of statement. Again, it'd be like, somebody wearing a Confederate flag, having, there's just a much more powerful, symbolic issue with those types of kind of clothing statements. And in this particular incident, it caused a significant amount of tension and not quite to the point of fights, but very close on the plant floor. And so, I think that's going to be an issue going forward. I think this is not the first of those types of situations that we're going to see. And so I think, we go back then to, kind of pull back and look at policies, the off-duty conduct statutes that may be in the states in which you operate. I think that in certain circumstances, employees shouldn't be disciplined or subject to discipline solely because of a message or an opinion that gets expressed in the workplace. But, then you've got to look at, if you allow that, and I've got those considerations there, how else is it going to impact the business? Is there a demonstrable link to that outside political expression to the proper running and operations of your organization? Are there greater risks that any sort of response statement or response action could then otherwise violate a company policy? Or does it go back to the hate speech issue? Does it violate a state or federal law in that regard? I think a number of companies have decided to implement, or if they already have one, then republish a carefully drafted and uniformly enforced policy on political speech, social messaging in the workplace, and why, as an example, you would not allow the Black Lives Matter face coverings or T-shirts. Again, there's that fine line between the protected under, concerted protected activity under the National Labor Relations Act, or does it, violate some other policy that you want to, you just be consistent. So I think in many cases, a number of companies are saying no political statements, no MAGA hats, no, obviously, I would certainly say it doesn't even matter on that, no Confederate flags. I'm really anti-Confederate flag. But nothing, either company logo only or something neutral. And, that goes so far as to even can you wear a Cubs mask versus a White Sox mask? Depending upon where you are, that could be controversial too. So I think in a number of places, companies have issued either branded masks to wear or just said, it's got to be plain or, simple pattern with no messaging. Because I think the difference to me are you, are you going back as the employee crossing that line? Are they otherwise engaging in protected speech? Like the Support 15 movement that was a couple of years ago. That's a close term and condition of the workplace versus, again, the MAGA hat or something that is clearly offensive and it would, shock the conscience or be otherwise offensive to a reasonable person. If we all go back to our law school days, what would offend a reasonable person? Then I think you've crossed the line and it's time to step in. So that, is kind of our current, how we're suggesting and how we're guiding clients when you've got, issues of that nature. Next slide, please. So the last scenario goes kind of back to one of the questions that was raised earlier was, if somebody shares something on Facebook or says something that is racially charged and that otherwise wouldn't be allowed within, the company confines, again, company property, it makes more sense in the virtual world in which we're all working. I think you've got to take into consideration that as well. If somebody's got, an inappropriate statement, on their Zoom background screen, the world is changing, unfortunately. So I think we've got to really think about, what's the context and where is it happening. It looks like I'm getting a couple of questions, and I just want to make sure that I'm seeing them, and I didn't, so I apologize. Hold on just one second. So I think from a personal experience, I think people, as I mentioned earlier, people are tending to get offended pretty quickly on these types of issues. And I'll go back to what I said earlier when we had the various circles up. If it crosses the line, then I think you do need to step in, investigate, take prompt remedial action as possible. And this is going to be something that we're going to have to think about it in the context of, what's our new normal? What's, is this something? And again, I think it goes back to, does it otherwise violate company policy? Somebody had mentioned earlier, and I think, and there's a bunch of questions here that I didn't see before, so we'll get to those in just a second. Somebody had mentioned before the presentation this morning, and Catherine had forwarded it to me, that these are tough topics, as you all know. And I think we're at a phase in our world population where we need to be aware of them, and I think we need to be addressing these types of issues. I found from personal experience that trying to have a dialogue can be difficult. And I think that, in my opinion, if you're going to try and bring these conversations into the workplace, it would be a good idea to do it with some sort of professional moderator or someone who's engaged in kind of the disruption of these types of quote unquote stereotypes, who can help you guide the conversation. I think that it's got some real potential for some flashpointing, and we have had some very good discussions around the firm on how we kind of break down various stereotypes and break down barriers and be more diverse and inclusive in the workplace. I'm a little off topic, but my point is that when you've got these types of off-duty conduct that comes in and crosses the line, if it becomes or feels like it's permeating or it's going in a direction that you need to change, I would consider discussing bringing in a professional diversity individual who can help guide and shape your conversation. So, all right. So with that, there are a bunch of questions that I wasn't scrolling through, so I apologize for that. But let me just see if I can answer a couple of those. And before I do that, hold on. I'm going to give you all the code for the CLE today. And you'll get, as I mentioned, when we're done with the presentation, there will be form that comes to all of you, and you'll just need to fill it in and send it back. For the CLE credit, you'll get a credit form then afterwards. So the code for today is SS, S is in Sam, S is in Sam, Seyfarth Shaw, 3712. SS 3712. Okay, so let's go back and look at some of these questions here. Can you share the thoughts on how to approach employees who express disagreement or disdain with the Black Lives Matter movement? Some employees may see this as discriminatory, others see it as a freedom of expression. Yeah, so that's a great question, Kendra, thank you. I think certainly, you know, it's one of those where you're like, if it came to me, I would say that if, depending upon where the discussion is happening, that you need to be incredibly careful because that, in my opinion, could bleed over into violating an anti-harassment policy. You know, if somebody's having a discussion where they're expressing disagreement with this particular movement, that could create potentially a hostile work environment. And again, this is all kind of very high level. I'm not saying it is or isn't, but that it could at least be a factor in someone saying that they had experienced a hostile work environment, because particularly if the company is aware of and does not respond to the discussion, then I think, you know, there's at least some potential for liability in that regard. And so your obligations are, of course, to investigate, to remind everyone that we're to have a respectful workplace. Certainly, people are entitled to their own opinions, but when those opinions bleed over into the operations of the company, then I think you've got to pull back and kind of shut it down, as we had to do in my personal scenario over the weekend, because it was getting offensive and people were very upset with the way certain people were conducting themselves. And we just said, this has got to stop. And I think the same thing can happen in the workplace. Let's see. Susan's got a question. Says that in Illinois, might a social media post be a lawful use of Facebook as a product? Not sure I understand the question, Susan, but I think that certainly again, I think people are entitled to post on their personal pages, and certainly, you know, different conversation if somebody's posting, you know, on the company's page. If you've got a company Facebook page, you're going to want to be monitoring what's being said there, both to delete if it's inappropriate or not in keeping with values, or if someone is complaining about comments that are being made by employees. And again, whenever it bleeds over into the workplace, then I think you have an obligation to at least investigate. You know, I'm not sure the part about lawful use of a Facebook as a product. I don't think there, at least from my understanding of the definition of the off-duty conduct, I don't think it falls into that category. There's not a lot of case law on that yet. I think it's more designed to, frankly, I think it was enacted to focus on the marijuana legalization issues. And so that, I think, you know, we'd probably need to think about that a little bit more. But yeah, I hear what you're saying on that. Question here, again, going back to the Black Lives stuff, it says, but how can we say it's purely social when the Black Lives Matter is coupled with unions and organizations like Fight for 15? Does that change the speech at all? It can. Yeah, I think that's a really good question. I think, again, it's more, it's tied, but certainly the Fight for 15 is terms and conditions, wages, you know, things that are happening in the actual workplace, you know, that we're supporting a movement that is designed to increase, mutually aid and benefit people by increasing their salaries. I think there's a distinction, although it may be a very fine distinction, that, you know, the Black Lives Matter is more of a social and how we're treating and interacting with you know, Black and brown people, people of color in the world on a more kind of global humanistic aspect. And that's why, you know, there's a ban in certain circumstances why employers have said no political activity or no political statements in the workplace. And, again, now you're getting into the really hard questions. So, I think each scenario is unique. I think each scenario needs to be evaluated based on the context of how it's coming up. And it's fine if as a company you want to say you can wear X or Y because we support this particular organization. But in my example, then how do you respond then to the folks who don't agree with it, who don't want to support it? And are their response comments, then are you treating people inconsistently? And some companies are willing to take that risk, and they're willing to say, yeah, we support this, but we're not going to support this. That's fine as long as you can justify it. But I think the potential there is, that someone would say that you're treating people differently because of a protected category. I'm not sure it would really fall into that, again, because it's just it's a movement as opposed to, a racial or a gender or a sex issue. But it's risky. And so I can't say that there is a specific bright line on that. But then the question right below, the one that I was just talking about, but isn't some speech inherently violent or unsafe? Of course, absolutely. And that's why I was talking about, to your point, the Confederate flag. There are, it's much like, God forbid, we have cases where, people find a noose hanging in the NASCAR issue. The claim was that there was a noose hanging in the particular African-American driver's stall, and how did it get there? I think it turned out that it wasn't, or it had been there. I don't remember the exact details of it, but certainly those are inherent and just conjure up inherently racial concerns, and I would absolutely shut all of that down. That's why I think the ban on any sort of Confederate flag or something that has that type of concern, that you absolutely would want to not allow that in the workplace. I completely agree with that statement. Let's see, just run down. Sorry, I've got to scroll down in the chat function here. So Catherine had mentioned to me that there is a topic coming up on these travel bans. There is a template policy, I believe, that we put together. Kind of the, for lack of a better word, the get out of jail free card. I'll need to see if that's ready for public consumption, and if it is, I can forward that along. Let's see. The next question here from my friend Isabel, nice to see you, says, let's say we have two separate complaints. One employee is taking an issue with a coworker's Black Lives Matter post off duty, while the coworker complains about the employee's anti-Black Lives Matter. Can we take action against all lives matter, but not the Black Lives Matter? Arguably, the anti-Black post could be conceived as racist. Yeah, I think this is where the kind of the concern has been all along. Is how are we going to address that? I think it goes back to the point about certain things are inherently racial. I thought an interesting post a couple of weeks ago where it said, no one's saying, in my opinion, again, this is just me talking, of course all lives matter. Okay, nobody's saying that, somebody who is not a person of color, that their life doesn't matter. Of course not. But right now, and I think the focus in our political discussion is that there has been, at least in many people believe, systemic concerns, that there has always been an issue that we are just now beginning to scratch the surface and try and address. And so that, the way it was said, and this is not my words, but that we're just trying to help out this particular movement at this time. And I think it isn't easy. And please don't, I just want to make sure that everybody understands that there's going to be a lot of discussion. There's going to be a lot of pain points around this particular topic, and that if you're taking the stance that this particular issue is important to the organization, great. I think that's important. But then you need to be prepared to explain why an All Lives Matter or anti-Black Lives Matter statements are offensive, are not fitting with the corporate culture that you're trying to establish, and that can be viewed as, I don't want to use the word white supremacist, but that it's exclusive, and that you're not going to allow exclusive speech, that you're going to try and maintain, and you're going to promote inclusive speech and conversations within the workplace. I think, and there are a couple of questions here that are all about, the same sort of thing, like how do you understand, how do you distinguish between what's political versus what's social? I think it goes back to how you're going to what's the company's stance on it. I think if you're going to, there's a question here, it says, what if the CEO came out with statements? Okay, if they're supporting, again, I think the conversation is around being inclusive. It's around recognizing that there are diverse opinions on particular topics, and that the dialogue itself is going to be one that is going to recognize and embrace differing viewpoints. When somebody comes out and doesn't agree with that kind of corporate cultural stance, or says something that could be perceived as threatening to that corporate cultural stance, then I think you're crossing one of those lines, that it's being disruptive in the workplace, that it is otherwise violating a code of conduct. It's otherwise violating a social media policy that says you can't, that we're not going to tolerate racially inflammatory speech. So I don't think there's a one-size-fits-all answer to some of these questions. I think that they're, again, I kind of go back to my Black Lives face masks versus all white lives t-shirts. If you're worried that there is that tension that can't be easily resolved, or that you're not ready as an organization to easily resolve it, it might be easier as an organization to simply say, we're not going to allow it, period, full stop. And if people come up and say, well, why not? Then you can, by all means, please use my example. That we've got, it's very emotional. It's very, for some people, it's very threatening. And we're not here to be emotional or threatening. We're at work to get jobs done. And if people want to have those conversations offline, if they want to have them after hours, if they want to have them when they're otherwise not supposed to be productive in the workplace, that's fine, as long as it doesn't bleed back in. And so, if there's a question from Deborah that says, what about, prohibiting messages about all lives or blue lives? I think you've got to decide where your comfort level is within the organization, and what you're prepared to do from the standpoint of how are we going to address this consistently, and is it one that you're ready as an organization, that you feel like you've kind of reached this level of enlightenment that you can have that conversation. I'm not sure everybody's there yet, and so then I think you've got to make a decision on your own, or not on your own, but within the context of your organization, as to what makes the most sense right now. And sometimes completely shutting it down may make the most sense right now. So, just one second. I feel like my cursor bar isn't moving, and I want to make sure I've got all the questions here. I think the last one came in at about 9:40 from Deborah, but if there are other questions that anybody has now, I'd be happy to try and answer. Julian, you want to go to the next slide, please? Okay. Questions. I think, again, remember that our, kind of everybody keeps talking about this new normal. It doesn't feel real normal to me. I think we've had, there's still lots of questions that need to get answered. I'm sure some of you are involved like I am in, litigation and EEOC charges and that sort of thing. So there's a whole, what's the court system going to look like as we go forward? Law 360 this morning said that the Northern District of Illinois is going to be allowing one trial at a time. Think about that. It's going to be years before cases actually go to trial. So, I'm a little off topic on our social media issues or on our off-duty conduct issues, but we've got a long ways to go yet. And I think, I think there's a lot that people want to, the people we're just going to have to, as I keep telling my kids, we're just going to have to wait and see. Just going to have to figure out what's going to happen. So, two other questions. Would employees who are subject to customers who wear these types of symbols, like All Lives Matters, have a claim for a hostile work environment? To customers? Potentially. I think the person would have to make the argument that the conduct or the conversation was severe and pervasive. I mean, if it's a one-time customer who comes in and they're only in the store or the location for a few minutes, I don't know that it would meet the sufficiently severe or pervasive, or that the duration of time that the person was exposed to that individual would be, that would rise to the level of a violation of Title VII. But I do think, potentially, and certainly there's been a lot of discussion around an employer's obligations to protect individuals from third parties. I actually did a trial on this a couple of years ago where there was a third party person who came in and was quote unquote stalking an individual. I diverse, but the EEOC in particular, over the course of the last couple of years, has been watching the way that employers respond. There is obviously an obligation to respond to complaints of third party conduct. I think the fallback is how long was that interaction between the two individuals, and so I can't say in a vacuum that would in fact be a violation. It could be, and I think you need to be aware of it. So, let's see. If Catherine's question on that point was a member question, if companies have not addressed issues with third-party contractors, what should they do? I think that, along the lines of now is a good time to republish or reaffirm the company's stance on certain topics. I think this would be one that you would want to include if you've got contractors, vendors, people who come into your organizations on a regular basis, that they are also expected to behave in the ways that you're telling your employees to behave, and that if they can't or won't, then you have the right to dispel them from your property and ask, if you've got a temp on site or you've got a contractor that you've hired who's not behaving in the way that you find appropriate, you have the right to ask that person to be removed. You have the right to refuse, an individual into the premises if it's a customer, that sort of thing. So I think that those, certainly you have an obligation to individuals who may or may not be exposed to third parties. There are limits, of course, but I do think you've got to at least affirm and remind everyone that there are, let's play nice in the sandbox type behavior standards that everyone needs to abide and to play by. Oops, sorry. Yeah, I think, well, the last question I see right now, it says, is All Lives Matters at the same level of danger as a Confederate flag? I don't know the answer to that question, I'll be candid. I think it certainly could raise, I don't think, if it's on a continuum, and those of you who either were at Seyfarth or have done Seyfarth at work training, we do the red, yellow, green continuum of appropriate and not appropriate. I would put Confederate flag over in like dark red, like don't even go there. I would put all lives matter certainly in an orange yellow zone, like this is going to be problematic. Um, I think that there's a lot of, um, I think it's, at least in my opinion, and again, this is not something that's been litigated, it's not something that there's case law on, but I think just kind of reading the tea leaves, I think it's trending in that direction, but I don't know enough about kind of where it is on that continuum to say, yes, it's the same. I think it's potentially it's certainly controversial, and I think has the ability, that there's going to be a clash, as there was in the client example that I gave. So, I really think that those are concerns that you as an organization need to, have some discussions around, and whether or not that's something that, you're not ready for. And so kind of shut down the whole, keep it a neutral face covering, keep it a company branded face covering or a t-shirt, may be where you feel the most comfortable right now, kind of given where we are both in our social and political climate point. All right. I think I've answered all the questions here. I'll go back when we're done to make sure. I just want to, as I'm scrolling down, I think that was the last one. Sonali, thank you for that. Just look over here. Got two chats going, so yeah, it's the same. I think it's the same. So I think I've addressed them all. If I haven't, if you could just go down to the next slide. Feel free to reach out to me. Thank you, first of all, to Catherine and to the organization to allow me to present with you. I've been a fan of the work that you guys are doing and the way you do these conversations. I've been hearing about them and what great work you've done for a long time. And, would love to come back and talk to you, particularly if we could do it live and in person. The webinars are hard in that regard. But if you've got questions, feel free to reach out either through Catherine or to me directly. The slides will be coming to you a little bit later. And if there are questions or if, and again, we're recording, so if you've got anything afterwards that you want to talk to me about, I'd be happy to try and set up some time. So enjoy, have a wonderful day. Hopefully it won't be so humid as it was yesterday. And I'll say thank you very much and enjoy the rest of your week. Take care.